case briefs, and so much more. LSData's got what you're looking for.
In 1974, the U.S. Supreme Court heard a compelling case, Howard Johnson Co.'s obligation, or lack thereof, to hire the old employees of a company it had bought, Grissom. At the heart of the dispute was the issue of whether the new owner of a business is required to keep the original company's workforce intact and honor its existing union contracts. The Grissom Union had filed a lawsuit against Howard Johnson, claiming that the company had flouted the contract's laid down instructions by not hiring all Grissom employees. The union accused Howard Johnson of a lockout, arguing that sustaining the collective bargaining agreement would require the company to employ all the previous employees. This altercation was initially brought before a lower court, which decided that the matter ought to be settled through arbitration, a resolution attempt where a neutral third party hears both sides and offers a solution. However, this ruling did not sit well with Howard Johnson, who appealed to the Supreme Court. The Supreme Court, led by Justice Marshall, decided to disagree with the lower court's decision. The court noted a significant shift in the composition of the workforce, with only a small portion of Grissom's employees being hired by Howard Johnson. This invoked the question, can the union compel Howard Johnson into arbitration to discern their potential obligations based on collective bargaining agreements that were previously signed by Grissom? In a rousing judgment, the Supreme Court ruled that Howard Johnson was not required to retain the Grissom employees or respect Grissom's union agreements. It claimed that the previous case of John Wiley and Sons v. Livingston was irrelevant due to the substantial changes in the workforce. Thus, the Supreme Court overturned the Court of Appeals judgment and underscored that a company that acquires another does not have to automatically adopt its workforce and existing contracts. This landmark ruling set an important precedent for how businesses handle acquisitions in the future.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.